when we were before the magistrate yesterday. Sat with the accused persons in the cells for 2 hours yesterday, for 2 hours. I'm familiar with cells.
Yes.
And we left without being told that the charges had been filed. That's a true state of affairs. We're leaving the court, it was about 1 p.m. here.
Yes.
The other matter for consideration is that dealt with the question of what to do with the accused persons who are not here. And we wish to address you on that issue, on the status of the warrants. But for record, these people were in police cells for 15 days without charge. And it is unfortunate that that issue can be dealt with casually, that persons can be arrested, stay in as counsels, that we tried to make sure that this matter is dealt with as expeditiously as possible. So we requested that the matter be placed before you. Today it was at our request.
Okay.
But unfortunately we have not been able to reach the other accused persons in time for these proceedings this morning. Yep.
So if there's nothing else to submit on,
Yes.
then I'll go ahead and give my directions.
Much obliged.
Okay.
Like this, the prosecution would object to bail. The prosecution, or the prosecutor, is a law officer and should not be seen to be interested in a particular outcome of a case. Even on an important application like this relating to bail or bond. The prosecutorial policy emphasizes the role of prosecutors as officers of the court. And to make statements which are openly against the spirit of the Constitution is a serious matter. And I just want to demonstrate a few things that would point out to the casual, with respect, manner in which this matter is being dealt with by the prosecutor, and making submissions which are not in sync even with the documents they have filed. And the most important one is the charge sheet. Is provided it in law and is required to contain vital information that I would to say what I want to say. You may not like it, but I think it's not in good spirit. If you look at the charge sheet, Your Honor, the names of the accused persons are given. There is a column for identity certificate or passport number, a meticulous prosecutor or an investigator would place the ID number in the charge sheet. I've seen so many times that done by prosecutors file a charge sheet. So it'd be evident from the ID. Do you have my ID? Which I'm able to obtain from him from court. It gives his personal details. The investigator would say that I obtained or from Siaya, Oranga, Usonga, Nyadorera, even the little village. So what I'm saying is that and be able to, or a passport number, be able to make that determination. And you see address, the last column, address include district and location applicable. And they say care of republic. Care of republic. It shows the attitude and the general conduct of the prosecution in preparing even the charge sheet. How can you take their statement seriously when right before you, Your Honor, I'm able to obtain an ID which shows and demonstrates where Cleophas comes from? The county, the sub-county, the ward, the village. All there it is in that, is there. Now, if you compare what they are saying in the affidavit in which we have submitted that it should be struck out, like the paragraph they rely on include paragraph 1A, lack of a fixed place of a board. And the statement made or the averment is the accused person do not have a known permanent place of address within the jurisdiction of the Honorable Court or any other variable fixed place of a board. How did he come to that conclusion? This is just a blunt statement. I think if you want the court to believe that he has got no fixed board, the investigator should tell us what he did in order to come to that conclusion. It's a statement without a foundation. You would have said, I tried. And should have addressed each accused person. He cannot just say the accused persons. He should say that in relation to the first accused, this is what I did to determine whether he had a fixed board or a permanent residence. On the account of the second accused, this is what I did, and came to this conclusion. No, not this statement without a foundation. Yes. There's no factual foundation for him to make that statement. And then they're saying there's a significant risk that the accused persons may abscond. What is the foundation of making that statement? It's just like saying, I believe Orengo is a madman. There must be a factual foundation. This is not how we practice law. By making statements which cannot be, as a matter of law, considered to be evidence.
Yes.
And one of the reasons, one of the ways to demonstrate a flight risk is to, for example, give a previous case where a person was given a bond and it failed to appear in court. That would be a factual foundation. And Your Honor, this threat, the accused persons are likely to face hostility from members of the public. Again, no factual foundation, are likely. These two accused persons are here in court. They were in court yesterday. And there's nothing to show they have showed any hostility to them. The only fear they have is the fear of the police, because once they were arrested, the police, they stayed in custody in 15 days. That's the only thing they fear, my friend. And he says the well-being of the accused persons cannot be assured. I mean, what is the constitutional role of the state, the police, the security of the person? Article 29, security and freedom and security of the person. And that security comes from the state for each and all of us. So what are they saying? They're saying you are likely to be beaten out there. That is your problem. But if you can't look after yourself, we have a cell waiting for you where you can stay for as long as the case goes on. And the other reasons, I leave it to the court, because again, there are no factual foundations to those statements. They are just generalized statements. Your Honor, the purpose, first of all, there's a presumption of innocence, the doctrine of presumption of innocence. And bail and bond is to secure that doctrine of the presumption of innocence. Unless there are compelling reasons. A bail should always be given as a matter of fact, even without an accused person applying for it. And the purpose of bail, in addition to protecting that doctrine of presumption of innocence, is to secure the attendance, as my learned friend Mr. Mawo has submitted. The two accused persons before the court have not been brought here under a warrant of arrest. They have not been arrested. They have come to court on their own volitions. They have not been served with any summons. And they have appeared. And Your Honor, as you indicated earlier, in a civil and democratic society, securing the attendance of a person, as you observed, is not just through arrest or executions of warrants of arrest. A summons is sufficient. How many times free bonds are given is sufficient. So long as the court is persuaded that in the circumstances, the accused person will attend when required to attend court. And from I've heard from the prosecutors or the prosecutor, there is nothing they have said that demonstrates that these two accused persons, because we're now dealing with these two accused persons. We're not dealing with the others. Their matter will be dealt with. Coming to court on their own free volition, without a warrant, without a summons, that is good enough to demonstrate that they will appear when required to attend. Your Honor, we have an authority here which we would want to share with the court. Is a matter, which arose. I have a copy in circumstances maybe similar to what you're dealing with. The case of Victor Munyao Sirisia and 41 others. These cases arose during a public demonstration. There was some kind of tumult, if I may put it that way. Just as in this particular case, there was some kind of tumult around the church. And several people were arrested and charged with offenses, including robbery with violence. If ever there could be a felony, robbery with violence ranks high in penal code, probably second only to murder and treason. Previously, it was a capital offense. And in this particular case, the trial court granted bail in the sum of a surety of 300,000 shillings and alternative cash bail of 100,000 for an offense of robbery with violence. And to it, there was also the offense of malicious damage to property, like this one. And there was also the offense of assaulting police officers. The matter was, the ruling of the court was, the trial court was appealed in the High Court, and the terms were reduced to a bond of 100,000 shillings and a cash bail of 30,000. And when the matter went before the magistrate, he further reduced it to 15,000 shillings. Your Honor, I want to invoke the spirit of our Constitution. I consider that this Constitution gave us a second republic, a new constitutional order. And the spirit of this Constitution is that is in Article 19. It is my favorite article in the Constitution, because it defines what type of state we are. And it states the Bill of Rights, which includes the right to bail, is an integral part of Kenya's democratic state and is the framework for social, economic, and cultural policy. And then it gives the reasons why it is important to protect individual rights. And it says in Sub-Article 2, the purpose of recognizing and protecting human rights and fundamental freedoms is to preserve the dignity of individuals. Putting up somebody in a cell who is presumed innocent is not protecting the dignity of the individual. Your Honor, you should have seen the accused persons yesterday after 15 days of police custody. And is also to promote social justice and the realization of the potential of all human beings. And then it emphasizes the rights and fundamental freedoms in the Bill of Rights belong to each individual and not granted by the state. So the spirit of the old republic, and Your Honor, if you looked at the old constitution, key to the enjoyment of Bill of Rights was security of the state. This new dispensation puts the individual at the center of our state and the sovereignty of the state. So I urge you, Your Honor, that you grant bail to the two accused persons, and they invite you to the principles set out in this case. They dealt with the question of affordability, that when you grant bail or bond which are in terms which the accused persons ordinarily would not be able to afford, then that would be a denial of that fundamental freedom. And repeated that grant of bail should not be anchored on the value placed on the property in the case of malicious damage, because there was a charge of malicious damage. So they said the court should not look at the value. It should be concerned more about the principle of granting bail in terms of the Constitution. I think it's a good authority. There's reference to case law, Kenyan and from the United States, and judicial sentencing guidelines So I commend that the court considers this case in making its ruling on this matter. I, in fact, would urge the court that since these two young people have shown to be good citizens, coming to the court on their own volition, a free bond would be commendable in the circumstances.
Anything else?
I thank you, Your Honor, and I cannot sit down without appreciating how Your Honor made it possible for us late in the hour to be heard beyond 5 o'clock yesterday. I thank you.
Yes. Any rejoinder from the state?
I'll address the issue of the application to strike out the affidavit on the grounds that the same was prepared by a person who was able to practice the certificate. Your Honor, the person who signed the affidavit is a state counsel working in the office of the Attorney General. And although from the documents submitted before court indicate that she does not possess the current practicing certificate, our submission is that the result should not be sufficient ground to strike out the affidavit. And in our submissions, relying on the first authority, the High Court of Kenya, the Civilians Application number 7 of 2026.
Your Honor, would they be in a position to cite authority? They have returned a new one. But because we are entitled to respond to the points of law. But it's being raised now. So I think in the order of things, it should have come much earlier.
So, you know, we're at the tail end of the application, the hearing of